The following program is paid for by EG Tax. All opinions or statements expressed on this program are solely those of EG Tax or its guests and do not reflect the opinions of News Radio 930 WBEN or Odyssey.
The following is paid programming.
It's time to talk taxes.
New friends, new opportunities, new partners. EG Tax.
It's Ask the Tax Lady with Esther Gulius and EG Tax on News Radio 930 WBEN. To reach Esther now, call 803-0930. Toll free at 1-800-616-9236. And cell calls are free at star 930. And now, live from the WBEN studios, it's Esther Gulius.
Well, hello, Buffalo. This is not Esther Gulius. It's Chris Fabian here from EG Tax. We're here to help you with your tax needs. Any questions you have, feel free to give us a call here. I'm joined in studio with my beautiful wife, Tiffany.
Hey, good, happy Saturday.
Yes, happy gloomy Saturday.
Yeah, I think Esther's vacationing somewhere warm, so she wouldn't want to trade places with us right now.
Exactly. But we're here today with Jeff Katz, like we promised you guys. He is here in studio, live and in person. So if you have questions for, wills, estates, life estates, there's a new rule now out there for homes, which he's going to get into. Give us a call here in studio, 803-0930, 803-0930. Text it in at 716-803-0930. And I know I said O and not 0 for that person out there. But we got our seminar.
It seems to roll better when you say
yes.
O.
Yeah, we got our seminar coming up, right, Tiff, in the beginning of October?
Yep. It's financial planning and more than anything, budgeting. So... right now politicians are all talking about the economy and ways to navigate this crazy economy and tools and tricks. So we're going to have financial brokers there. We're going to have budget forums for you to do and ways and tricks and tips to save money even in this tight economy. And so that's certainly what we're going through right now. And if you're interested, you can go to egtax.com and register, or you can call the office at 632-7886. And it's a great opportunity just to look at your finances realistically. Esther always says you shouldn't spend what you don't have, and you shouldn't live above your means. And right now, with the way that things are going, it's hard to stay within those means. And so hopefully we'll just give you a different perspective.
Right. And then our tax school is also coming up in October. We got classes all over the town, I shouldn't say town, the area, from Fredonia to Niagara Falls to Batavia. So we got the area covered. We got in between there too. So if you want to learn taxes, and most importantly, if you want a job in the tax field, that's how you do it.
Yeah, it's a great way to learn taxes from A to Z. There's also an online option, and it's lots of fun. And I remember Esther telling the story when she took her first tax class, and here she is. I mean, you're always, like Esther says, the hit at the party, right?
That's right. And and like I said, we do have Jeff Katz here, elder care lawyer. And I'm going to start off a question about budgeting. Do people's debt die when they die?
That's a great question, Crystal. First of all, thanks for having me. Happy to be back. I seem to be doing this every summer with you guys, and really appreciate it. And certainly have known Esther and EG Tax for a long time and appreciate the relationship.
Yeah, same here.
Thanks. In terms of debts, when someone passes away, the debt of an individual does not die. It does not transfer to the heirs. It does not become an obligation of the kids or anything like that, but it does remain an obligation of the estate. So if someone owes money, say to a credit card, and an estate is opened up, that credit card company has the right to file a claim against the estate and to get paid. So debts do not die with you. They do stay and become an obligation of your estate.
Right. So, I mean, just think I see a lot of clients all the time. You do too. And I could just see some people going, why should I pay my bills when nobody's going to have to worry about it? When I'm gone, they'll be gone too, but that's not true.
So it's not true with, in essence, the exception of if you have no money, in other words, you have no money in the bank, you don't own any real estate, and you do have debt, well, then there's nobody to, for that debt to be collected against. Your estate would not, if your estate is insolvent in essence, that debt does not, there won't be any obligation to anybody else. But debt as a legal and technical part, debt does not die. So it does not die with you. It would remain an obligation of your formal probated estate.
Okay, I got a follow-up question, which is going to lead to the new real estate, what you were telling me about earlier. Would a TOD be an exception to that?
So what happens is the debt of the individual can become an obligation of the estate.
Right.
When we say estate, so let me explain this for our listeners. Estate is a technical term for a probated estate. In other words, somebody passes away and they need to pass. Let's say they have a $100,000 bank account without a TOD on it. If they've got a TOD, as Chris mentioned, is transfer on death. That would mean it would go to whoever's named on the TOD. Let's just say in this example, it's the two kids. So the two kids would go to the bank, give them a death certificate, and they would get the money out of the bank. If it's in their individual name, then it has to go through the probate court, which would either be probated with a will or go through administration without a will. And then going through that estate, if there's a debt owed, then that debt becomes a debt of the estate. If it goes through a TOD, then it would become much more complicated for the creditor to collect because there is not a formal estate.
Mm-hmm. Okay.
Wow. Well, you can tell Mr. Jeff Katz knows what he's talking about. So if you have any questions, just give us a call, 803-0930, 803-0930, star 930 on your cell phone, or you can always text in phone calls.
Yep. And also now, before the show, you were saying New York State just changed the way you can handle a house instead of a life estate or putting it in a trust.
Correct. There's a brand new law in New York State just coming on the book, so most people probably haven't heard about it, and it is something that I think is going to be very popular going forward. Although it's like any new law and any new planning technique, it's going to have its pros and cons. But what it basically is, most people are familiar with TOD, transfer on death. You could put a TOD on a bank account. You could put a beneficiary on an IRA, a beneficiary on a life insurance. And when that occurs, the asset passes directly to whoever you have named as your beneficiary. Up until just now, you could not do that with real estate in New York State, and now you can. So it's a brand new opportunity for planning. The kind of thing, quite candidly, that our listeners should talk to their attorney about, something I'm happy to help clients with. It is going to be, I believe, over the next period of time, something very popular that people are going to utilize. It's different than a deed with a life estate, which we've discussed on this program in the past, which relates to nursing home concerns and elder law. This is really just I would call it a probate avoidance technique, trying to make it easier for the real estate to pass to family members or, quite candidly, whoever they want, using this new TOD law that just got passed.
Okay. So again, Chris Fabian and Tiffany Fabian here from EG Tax. We're here to help you with your tax needs. If you got elder care law questions today, Jeff Katz is here from Katz and Berry. Please give us a call here in studio, 803-0930, star 930 on the cell phone. Text them in at 716-803-0930. We're going to take a short break, and we'll catch you in 2 minutes. That's right. We treat everybody as family, and that's why we do our summer series, to keep everybody informed not only of taxes, but everything that impacts their life. And today we're talking death. Hate to say it, but, everybody's got to die some sooner or later, and just like school, you got to buy your school supplies. You got to be prepared, going to college, going your first job, your wedding, everything has its steps.
Season.
It has its season, and we got to do that just as well for passing away, making sure our affairs are in order.
And that's always been my mantra, quite candidly, Chris, is that, you know, whatever our topics we're talking about and whatever our listeners are out there, is really to plan. Make sure you plan. After doing this for nearly 40 years, some of the worst cases in my career are always people who don't plan. And you know, whether it's writing a will, whether it's writing a trust, whether it's planning for nursing home care, protecting your family in some way, the importance of planning, I can't overemphasize in the estate planning world, and that's clearly you know, reasons I like to do shows like this, and that's certainly what I've been trying to help people for my whole career. So.
Yeah, just like us, we love to help, and you can call Jeff not only today but during the week. It's 633-3363. He's a great asset to have in your pocket. We're gonna go to the phones. And how can we help you?
Hi. Are you taking my call right now?
Yes, sir.
We are.
Okay. I wonder if you could tell me about a pooled trust. Have you heard the phrase pooled
That's
trust?
for Medicaid.
Everybody
course.
goes swimming.
Yes, no.
No, just kidding.
So a pooled trust would be a type of planning technique to help somebody protect or preserve their assets if they're dealing with Medicaid, qualifying for Medicaid. So there's certainly some very good pooled trusts here in Western New York. And if that's something that a family needs or an individual needs, I would recommend the use of a pooled trust in many situations. So are you talking about one for yourself or for a family member?
Yes. Yes. My wife and I are retired. We had a revenue last year, or an income earned in our retirement of, say, $150,000, and we have a trust for a handicapped daughter. And I heard that a pooled trust might be a way for us to protect our money much more efficiently.
Well, I guess just to answer quickly for you or for anybody who's thinking about a pooled trust, it would be utilized for yourselves if you were trying to qualify for Medicaid, trying to protect assets so that Medicaid would be your payer or your health insurance. Based on, you know, obviously on the radio we can't get into all the factual scenarios. Based on your question, I'm not sure, I just quite candidly, that a pooled trust fits for your particular situation. So I would recommend, you know, that you talk to, you know, feel free to give me a call, or if you do have an attorney, talk to another advisor, just to make sure, because with the type of income that you have, I'm not sure that, you know, just off the top of my head real quick for you, that Medicaid is going to be necessary for you. You know, if you have a special needs child, special needs planning is certainly something that that's very important. A lot of people have children who, or a relative or a child who needs some planning because of their situation or their inability to work. Then a pooled trust might fit even more in that situation. So I guess what I would say to you is, why don't you sit down with somebody, have a real detailed discussion about the use of a pooled trust, or whether there's any planning techniques that you or your family should be using, because we don't want, again, because going back to our mantra, we want to make sure you plan and plan well, so we don't want you to miss any opportunities.
How long have pooled trusts been around, as far as you know, for this in New York State?
Yeah, that's a great question. I really don't know. They've been around a long time. I mean, when I say a long time.
Oh, really?
Well, certainly.
Okay.
Off the top of my head, certainly more than a decade, you know, but I really can't go back to the formation.
Okay. Hey, thank you very much.
Oh, you're welcome.
Thank you.
Yeah, Jeff, correct me if I'm wrong, but because I work in the healthcare industry, and so a lot of my patients will need Medicaid, and so the money that they get in every month is too much and it precludes them from getting Medicaid. But if they put and open up a pool trust, they can set aside in the pool trust this for their rent, this for their utilities, this for their food. And so that hence brings down their monthly income every month, which would hopefully then qualify them for Medicaid.
Exactly.
Yeah.
So Tiffany, you've got it. You nailed it on the head. That's why I didn't think it really applied to this gentleman. But a pooled trust can be very effective way of preserving some income or planning for an individual who does need or is otherwise eligible for Medicaid. So
Yeah. Great tool. I think it's been around for quite a long time, and great question.
I mean, and it is. You definitely, so you want to talk to the right person to get the correct answers to see if it's.
yeah, and I think what that question really opens up is the Medicaid planning, which is a big part of what we use the phrase elder law, is a planning technique for families to try and preserve assets in the event a loved one ends up in a nursing home. So pool trust would be one small part of that. Other parts would be use of an irrevocable trust or deeding the property to the kids, maintaining a life estate. Basically, if mom and dad, if we got concerns about mom and dad not being able to stay at home, needing to go to a nursing home, the question is, how is that nursing home going to get paid for? And Medicaid is one of the options that could pay for the nursing home care, and that would involve some planning in order for the family to preserve assets for the next generation.
Yeah, which then, that's what we were going to talk about anyway, so it was good timing for this pool trust question. Because everybody's afraid that their money's going to go to a nursing home.
So basically what happens if somebody goes to a nursing home, it's going to get paid for one of three ways. First, it's going to get paid for by insurance. If you've bought a long-term care insurance policy, which most people don't have, and they've become very expensive recently, more so than they were, say, a decade ago.
Right.
That's one option. And health insurance, Medicare or another health insurance will pay for rehab. It'll pay for the first part of a nursing home stay for rehab. After that, it's either your money, private pay, or Medicaid. And in order to qualify for Medicaid, you have to reach the Medicaid qualification levels, which, and we could talk about those, but they're quite low for most people. For a single individual, it's approximately $30,000, and for a married couple, it's basically the home. So that you'd have a community spouse who would get to keep the home, and then the balance of their resources, we could just call that $130,000. And if you get over those levels, then Medicaid will not pay the bill, the family will. So what a lot of the planning technique that we lawyers in the elder law field use is trying to shift assets out of mom and dad's name so that Medicaid would pay the bill when nursing home stays would come around.
All right. So any questions out there for us, give us a call here, 803-0930, 803-0930, star 930 on your cell phone. But that's because there is the 5-year look back.
Correct. So the planning technique that I was talking about, which is transferring assets, mom and dad transferring assets to the kids as the common example, has to be done 5 years prior to applying for Medicaid. So if mom and dad transfer their assets away and then go to a nursing home 7 years later, more than 5 years, well, then those assets do not count as theirs in the Medicaid application process. If they go within the 5-year period, well, then those assets are within that look-back period and they would still count. So that's why planning has to occur far enough in advance in order to get those assets protected.
So now, here's the $1 million question. Say mom and dad give their kid $1 million, since it's $1 million question. Give their children $1 million, $250,000 4 ways. Okay, so it equals $1 million. Dad goes in a nursing home within the 5 years. What happens? Does the nursing home then go after the children for the money? How does that all work within that 5-year period?
Yeah, and that's Chris. Your question is very intuitive, or obviously shows how many people in this area you've been helping. So the issue here is who's going to pay for that nursing home? Dad's in the nursing home in this example. The bill's coming in. Nursing home costs in Western New York now range anywhere from $15,000 to $20,000 a month, which is a heck of a lot of money. And so the dad is in the nursing home. There is no insurance coverage. So based on our description of the money being given away within the 5-year look-back period, then dad is not Medicaid eligible. So Medicaid will not pay the bill. So now the nursing home has to get paid privately. So it's a private pay issue between the nursing home and the family. So Medicaid in that scenario is not involved. So the Medicaid program would not be paying the bill because of the transfers within the look-back period. So you'd be knowing that dad would, in that situation, not be eligible for Medicaid. And then it's between the nursing home and the family as to how they're going to get paid.
Yikes, right?
And yikes, because they do need to
Costly.
get paid, obviously, because
Yeah.
dad's in the nursing home.
Right.
So,
Right.
so it's Tiffany, it's a yikes situation, and quite candidly, the family would have to come up with the money to pay for it because Medicaid's not going to. So.
Yeah.
Very costly.
Right. You know what? And this could be something after the break, part 2 of this question, but I get asked all the time. My mom, we're selling my mom's house. She gifted it to me, not a life estate. She gifted it to me a long time ago because she didn't want a nursing home to get it. Well, now that we're selling it and she's going into the nursing home, I want to pay for her care.
Yep.
And I'm like, wait, you're defeating the purpose of what mom's wanted.
So children or anybody, any family member or even friend or whatever, is of course eligible to pay for somebody else's care, and that would in essence be a gift, or you'd be in that situation, the child be helping them out. So, but there is no responsibility. And Medicaid in that scenario, with the quick scenario with the house that was gifted more than 5 years ago, Medicaid, the mom or dad in that situation could be eligible for Medicaid. So Medicaid would be paying the nursing home cost. Yeah.
Yeah. So, okay. So we got to follow up on that after the news. We got a text we're going to get to as well. Give us a call, 803-0930. Love to help you. We'll catch you on the other side of the news. And we're back. Thanks for listening this Saturday. I don't think there's many picnics or golf outings
and
today.
no Bills game today.
It's 7 o'clock.
Later on,
Yep.
And so hopefully they fare. I know it's preseason, but it's always good if they play very well, right?
That's right.
So they can look at their second stringers or third stringers, right?
Yep. Let's get all our players a chance to succeed. And that's what we want you to do, is succeed in life. So give us a call here in studio, 803-0930, 803-0930. And we got text.
Sorry, before you say that, I said, Esther always says, don't bury your head in the sand. Just make sure you ask questions and make sure you've got all the answers, right?
That's right. So if you put a home in either a revocable or irrevocable trust, can you still use the equity for needed income? And what is the best option to use the equity?
Okay. So I guess the short answer to the question would be no. So if you're gonna put a house into a trust, and we could talk about trust, the difference between revocable and irrevocable, which we haven't done. But in short, if you need the equity out of your house, either through a home equity loan or a first mortgage or even a reverse mortgage, then trusts are probably not the way to go for you. I mean, it's not completely black and white, but in short, if you're going to be using the equity in your home to live on, or if you're going to be using the equity in the home for either home repairs or paying for things for family members, then you wouldn't want to put the house into the trust because you no longer own it. Especially if it's an irrevocable trust, then it's not your house anymore. It belongs to the trust. An irrevocable trust is a trust that you've created, which is in essence given away the home. So in short, if you feel you're going to be using the equity out of your house, a trust is probably not the right vehicle for you. Again, this is not a complete yes or no question, but just to answer the question as it was texted in. So if you want the equity out of your house, I as generally, just the big picture, wouldn't be recommending a trust for that type of client.
Right.
You know, Esther types up questions sometimes, and sometimes we use them, sometimes she doesn't. I think this sort of ties in. In an irrevocable trust, can you still manipulate assets so that you can get the stepped-up basis?
So if the irrevocable trust, again, the irrevocable trust is you giving away the assets. If the irrevocable trust is written as a grantor trust would mean that it is still a trust that's includable in your estate for tax purposes, then it would get a stepped-up basis. Just take a quick step back. Stepped-up basis for our listeners is that when you die, so if you had a house that you bought for $100,000 and it's worth $200,000 when you die, the basis would step up to $200,000, and that's the same for stock. So if you had bought $100,000 of Microsoft stock and it was worth $500,000, then the basis steps up when you die. And if you've transferred that into a trust, which is a grantor trust, then you would continue to get the stepped-up basis. Stepped-up basis is a very good law that we have currently to help people who are inheriting money, because it gets rid of the rather burdensome capital gains tax that you otherwise might have to pay when you sell an asset with a lot of gain. So
Yeah.
Okay,
good.
so we're going to go to Mike from Wheatfield. Hey, Mike, how can we help you?
Yes. My question is, can trust and life estates be broken by losing an accident lawsuit? Now, let me give you an example. Down the street, one of our neighbors was in an accident. She had her house in irrevocable trust to the children, but she lost the lawsuit, and they took the house away. So trust and life estates doesn't guarantee you that 100% you're going to save that house, right?
So the scenario that you laid out, the facts, I can't answer that one in particular because I really don't know the details of that. But in the big picture, if you have transferred your asset into a properly drafted irrevocable trust, meaning you've given it away so it is no longer yours, one of the other benefits can be creditor protection. So
but that's what she had. But again, if there's a lawsuit against her, say if she was in an accident, but even if her child was in an accident, either way, they could take the house away. It's not. It can be broken then.
You can't. So again, I can't. I don't want to debate or answer the specific situation you're talking about because I really don't. I don't have enough information to answer that one. But in the big picture, if creditor protection, meaning a lawsuit, is something that you're concerned about, or something that a client would be concerned about, there are ways of protecting it if it's transferred into a properly drafted a trust or directly given away. The situation you're talking about it certainly sounds unfortunate, and I can't really,
Maybe it was a revocable trust?
I think he's got
If it was a revocable trust, certainly that's not creditor protection, a revocable living trust, because that is a grantor trust, which they would continue to own, and that's not designed for creditor protection. So again, it's hard for me to know the specifics of that case, but I can say that one of the things that does come up in planning quite commonly is what happens in lawsuits. People are very concerned these days, and rightfully so, about if they do get sued for some reason, whether it's a car accident or something else, that they don't want to lose their assets. So there are ways of protecting it, for sure.
Well, we were thinking of doing a trust because we're elderly, but our daughter lives in Florida, and she drives like 200 miles a day for the job. Now, if it was in her name, she's more likely to get in an accident, especially down that 95 in Florida. So
yeah, 95 is crazy in Florida. But if it is in her name individually, then there is a liability issue. That's correct. If it's in the name of my quick answer is, if it's in the name of an irrevocable trust, properly drafted, where it's designed to shield the asset, then it would provide creditor protection. So in your scenario, I guess, Mike, just kind of to wrap this up for us, I think you should, either talk to myself or somebody, another attorney who's familiar in this area, to figure out what is best for you.
And when you do talk to somebody, express all your concerns. Don't, it's covered. Ask all the questions. Don't leave a stone unturned.
Excellent advice, Chris.
Well,
absolutely.
Yeah, that's what we usually hear. Do a trust, but there's a lot of, like, you really got to get to the nitty gritty, like you said. You got to
right and
talk to someone about it.
Yeah, I got to say, Mike, use a professional. I see people who, whether it's forming a corporation, doing a will, doing a trust. I just went on to LegalZoom. but if you don't know what you're doing, you could be missing it.
It's just that, our neighbor lost a very expensive house. So, okay, thank you.
You're
Thanks,
welcome.
Mike. Have a good day.
Which also, that brings up a question. I know I get asked this with a life estate. What happened? Mom's still alive. Okay, it's in a life estate for her children. One of the children, we'll say, is in law enforcement. What happens if her child gets sued?
Okay, so just take a quick step back. A life estate in general would mean mom and dad take the property, they deed it to the children, and they retain a life estate. Life estate is really life ownership of the property. Mom and dad get to live there. Mom and dad continue to pay the bills. Mom and dad would get all the rights of living there, would continue to get property tax exemptions. So it's a very common planning technique, been doing it for many, many years, and it does help the family protect the property. If it's a life estate where going back to your question, Chris, if it's a life estate where the family, where the children own the property in their own name, then that does raise the liability question. So as I say to my clients, when we're doing these types of deeds, you have to assess your situation for your children, because if something happens to them, lawsuit, death, divorce, any number of things in the life of the child, it could affect their meaning the child's interest in the property. Won't affect mom and dad. Mom and dad's life estate will still remain protected. So if we are concerned about that, might be another reason for an irrevocable trust to provide that liability protection or protection upon divorce or any of those other sorts of things.
Again, don't leave any stone unturned when you're talking to somebody.
Correct.
Okay, so let's go back to the phones, and we got Sue Ann. Hey, Sue Ann.
Hi. Thank you very much. I really appreciate this subject, and I believe the attorney said that the Medicaid, if the assets were less than $130,000 for a couple, or is it different for single, I assume, and it doesn't count the home, are there other assets that are exempt from that $130,000 total?
I think it's much less than 130.
Yeah, so Sue Ann, if you're a single, so that it's what we're talking about now is really the Medicaid qualification of the person who's in the nursing home.
Correct. Yes.
So if you're a single individual, the approximate amount is $30,000. So that, and if you're a married couple, then the spouse that's at home is allowed to keep certain assets, and that's where the house and the $130,000 came in.
Okay.
Plus, there's also a big wrinkle which we hadn't talked about because which is IRA assets or IRA related assets, 401k, 403b, any of those type of retirement assets.
Yes.
Are also protected. In other words, you can have an IRA of $200,000 and still qualify for Medicaid. So
that was my main question, the 401k and the IRAs.
Yep. So in New York State, those assets are basically treated as a pension, meaning they're treated as income for Medicaid purposes. So if you have using that number again, $200,000 IRA, you have to take a distribution off of that. Most people are familiar with the term RMD, required minimum distribution of say $20,000. The $20,000 would count as income, just like your Social Security, any other pension, etc. But the principal, the amount that is in the IRA, you can have that and still qualify for Medicaid.
Wonderful, thank you. So, home, 401k, IRAs, and is that traditional and Roth?
Traditional Roth, exactly, excellent.
Okay.
Yes, traditional Roth, 401k, 403b, any of those deferred assets, and then does include the Roth IRA too. So
wonderful. And is there anything else that is on that list?
That's a great question. Nope, I think that pretty much covers it. There's really the only other thing that would be on that list would be assets that the family has planned for and protected in advance of that 5-year look back. But for somebody who's just generally going to a nursing home and applying, those are the rules. So if somebody, just to expand upon it, somebody has $25,000 in the bank and has a $100,000 IRA and is a single individual, they would be Medicaid eligible.
That's great. Thank you, sir. You answered my question.
Thanks,
What a
Sue-Ann.
great
Great
name.
question,
I like her
Sue-Ann.
name too. Sorry.
Okay, we're going to go to a text before we go to the news. What happens to the transfer on death of a house if you need to go into a nursing home before you die?
Okay, great question. What that means is, so this again was that the transfer on death, which we can add to a house now, transfer on death for a bank account, any type of asset that has a transfer on death, that means you still own the asset. The individual still owns the asset, so it's not protected in any way, shape, or form. The transfer on death is just a convenience for passing that asset upon death. So if we specifically answer the question that's been texted to us, if the transfer on death of a house, if you need to go to a nursing home before you die, then the house still remains yours, and it's subject to all the rules relating to a house, which means that if it's a married couple, it would be an exempt asset. If it's a single individual, it's not an exempt asset. But there are some planning techniques with the house, right to return home, or letting them place a lien on the house. So you can still get on Medicaid. But in short, the transfer on death does not protect the house for Medicaid purposes.
Okay. We're going to take a break in a minute. 803-0930, 803-0930, star 930 on your cell phone. If you are on hold, something happened to the phone lines, just give us a call back and we'll get you right on the air. But we're going to take a short break and we'll catch you on the other side. Okay. And the Bills make me want to shout. That's all right, Dan. Chris Fabian.
The nicest guy.
Yeah. Chris Fabian here from EG Tax. Tiffany Fabian with me, my beautiful wife. We got 15 minutes. We're joined in studio with Jeff Katz from Katz and Berry. We're talking elder care and getting all your ducks in a row. And speaking of that, getting your ducks in a row, how often should somebody update their will?
Well, you know what? When we're talking about wills, we're really talking about, your overall estate planning, which would be a will, generally a power of attorney, healthcare proxy, and potentially a trust. So the most important is to get it put in place in the first place. And, many people don't do that. They don't do it in a timely manner, but they certainly should. Once you have that estate plan in place, the wills or whatever, and the other documents, it needs to be revisited certainly upon any change in your family situation, death, unfortunately, divorce, change with regard to your kids. Any of that would I would say require a revisit of it. Any change in your financial situation, if you happen to get a lot more money for some reason, win the lottery, something like that. Or alternatively, if, just as life goes on, I would say I generally tell my clients probably every 7 years or so if they're looking for a number. But really, it's mostly upon life changes. For most people, if you write a will and you leave everything to your wife, you leave everything to your 2 kids after that, it's pretty straightforward. Doesn't need to be changed very often. So if it ever.
Okay. Perfect. And we'll go back to the phones, and we got Len. Hey, Len, how can we help you?
I generally tell my clients. Hey, my son is in the process of divorce, and it's coming up where the judge is going to sign it in the near future. And it's been going on for a couple of years. So basically, his wife's father passed away. And he was in a home, but he has a pretty good bank account, I'll say. Is my son entitled to any of that in this divorce?
Okay, so under New York state law, the assets, we're a separate property state. And first of all, let me just say, I'm not a divorce lawyer. I've never done a divorce and thankfully have not been personally divorced. So I don't have, I'm not an expert in matrimonial law. Really my planning and my expertise is all in the estate planning and elder law field. But as a separate property state, inherited property, if kept separate, so being specific to your question, if that money never becomes joint, it's not subject to the matrimonial. So if she inherits money, it's going to be her money and not subject to the matrimonial.
Doink. Okay.
Mm-hmm.
All right. No problem.
Okay.
All right.
Good luck to your son.
Yeah. Okay. That's good luck to my account. Okay. Thank you. Bye-bye.
Bye-bye. Okay. And then we got a text. Okay. Assets besides. Regarding homes in retirement qualifying for Medicaid. What about automobiles, life insurance? I was told my life insurance does my Medicare.
Okay, well, it sounds like, so when we were talking before, of course, in this format, we can't, get all the information out. So I didn't mention anything about automobiles. So in the scenario of that we're talking about Medicaid, one automobile is exempt if there is a community spouse. If it's a married couple, the laws, of course, allow the individual who's at home, the community spouse, to keep an automobile. If there is no community spouse, so if it's a single individual going in, then there is no exemption for the automobile. The automobile would be treated as an asset. And life insurance, so though part of the life insurance quandary, of course, is what kind of life insurance is it? And the issue here is if it's a life insurance policy that has cash value. So some life insurance policies are term and they don't have any cash value, but life insurance policies that have I'm using the term cash value, have an amount that's built up in it. That cash value or surrender value, that is money that's counted for Medicaid. So if somebody bought a life insurance policy and it has a death benefit of $100,000, but it has a cash value that's accumulated of $30,000, it's not the $100,000, it's not the death benefit that matters, it's the cash value, that $30,000, because the individual has a right to take that money out. So that's counted in essence as just as if it's money in the bank.
Mm-hmm.
Crazy.
Yeah. Yep. I know when I'm doing offers and compromises, I always want to put the cash value. What is the cash value? Because that's an asset that you have. What were you going to say, Chris? I'm sorry.
I was saying crazy, but it also leads to my next question. When should somebody start, I hate to say this, start planning for a nursing home?
And, you know what? That's a common question in my office, and I would certainly, the first answer I would say, in the event of a unfortunate health diagnosis, if somebody who, regardless of age, gets a diagnosis of dementia, of Parkinson's, of some type of a disease that is likely to render them unable to care for themselves and have to go to a nursing home, then they should certainly immediately sit down with somebody and do some planning. Looking for an age, that's always a trickier question because, unfortunately, nobody has a crystal ball. So we have no idea if and when someone's going into a nursing home. But certainly as people pass through into retirement, that would be a time to look at it so that they're saying, all right, now what happens next in my life if I do end up in a nursing home? How's it going to get paid? How's it going to get paid for? So to me, it's either a health emergency or a health diagnosis, or when somebody's kind of into their 70s. We do have to remember we got the 5-year look back, so you don't want to start doing this planning when you're in your 90s. But it also may never be too late. So since a lot of this is Medicaid, I take it then, and you may know this one, every state is different on their rules? So in essence, yes. So certainly we're dealing with here, in our conversation here, we're dealing with really Erie County, Niagara County, which is all based off of New York State has its own Medicaid laws. Every state can have different rules as to Medicaid qualification, and does. Ours are all controlled by the New York State legislature in their implementation of the federal Medicaid laws. But yes, so in short, state by state. So if somebody is here in Western New York and they are moving to live with their kids in Indiana, then you're going to want to make sure you know the laws of the state you're going to. Or if somebody retires and comes to Western New York, I got lots of clients who have come up here to be nearer to their children here. They should certainly, that would be another time. Anytime, if you bring your parents from another state to Western New York, you want to make sure you sit down and get advice from a Western New York attorney as to the laws related to both estate planning, wills, trusts, etc., and to the laws related to elder law. So
okay, and then I know another question I get asked too, or I hear stories. People tell me you should always try to keep at least 6 months to a year's worth of nursing cash to pay for a nursing home so you can get your choice of a nursing home. Is that true?
Well, so there's no set rule. This is not a law or anything like that. But certainly, I think everybody always wants to make sure that their loved one, or if it's them, will get into the nursing home of their choice. And the way I always would look at it is, if you are applying to a nursing home, in essence, if you are private pay, you will go to the front of the line. You will have a greater choice in selection. So yes, I think it would be true. The more money you have, the easier it is to get your loved one into the nursing home of their choice. So, and that's always a factor when we do Medicaid planning and asset protection, just to make sure that the concerns of the individual we're planning for will allow them to have the best possible rest of their life. So,
Okay. And then another fun thing I have with clients, they come in and they go, I'm the executor of my uncle's estate.
Never again. Never again. They say.
Who should you pick to be the executor or executrix? How, if there isn't one, how is that determined?
So the executor is named in a will, and that's the person who's going to be in charge. And it's actually a job. It's a job the person can get paid for. And the job of the executor then would be to sell the house, deal with the tangible personal property, go to the bank and get the bank accounts, deal with creditors, as we talked about earlier.
Yeah.
Deal with
the people, the other beneficiaries.
And deal with the beneficiaries. That's always the hardest part for an executor. So an executor would be named in the will, and then executor would be appointed by the court, by the Erie County Surrogate Court. If you have not written a will, then there is no executor. It becomes an administrator, which would be a family member, next of kin as a first choice. One of the important reasons to write a will is to make sure you get the executor that you want, to get somebody who you trust, who you know is going to do a good job, and if there are family issues, who's going to be able to negotiate those family issues or be able to manage the finances if it's a complicated estate. So certainly that's another reason, as we keep talking about planning and writing a will, is to make sure you get the right executor and somebody who's going to do it right for you. For those who are executors, they always have to remember it is a job, and and you've been trusted by the person that passed away to carry out their wishes.
Right. So, yeah, and God bless you if you are one. Not the stories I've been told. But we're Chris Fabian, Tiffany
and
Fabian.
Jeff, why don't you give your phone number at the office?
Yes.
Go
ahead,
I've
Jeff.
not been talking much, so I just felt like chiming in there.
Well, sure, Tiffany, thank you, and Chris and Tiffany, thank you very much for having me on today. Happy to answer these questions. As I said, I'm a partner of the law firm of Katz and Berry. Our number is 716-633-3363.
And they're always there for me whenever I call. One of them will always call me right back and answer my questions, so they'll do the same for you. Chris Fabian, Tiffany Fabian from EG Tax. We're there all week, 632-7886. We'll help you with whatever questions you have, letters. Give Jeff a call, like he said, 633-3363. He'll love to help you, just like we love to help you. Until next week, we'll see you then.
The previous program was paid for by EG Tax.